Good afternoon. I'm Patrick O'Keefe, Irish name, German accent, and I will be the moderator for this upcoming session. Thanking Anne and the whole team of the CyCon for bringing us all together in this room, and I'm really astonished that so many people joined us today. I welcome you to the breakout session, Cyberspace Doubling the Legal Complexities. It's no news when I say cybersecurity is not limited to the traditional domains, land, air, sea, where I originate from. However, with growing military as well as growing commercial activities in space, safe and secure operations in a multi-domain environment, yes, that's another key buzzword that is coming up in the NATO umbrella, are more important than ever. However, cybersecurity in space has not yet found its place in a comprehensive security architecture as it should. Really happy to see you as well. Space governance and space law in particular offers way to mitigate the risk. Surprisingly, it does. Together with the team of CyCon, we assembled a team of experts to help us to understand the current situation and the challenges in governance and security in outer space, and possible solutions to keep us moving forward stronger than ever before. I have to say, as a former naval aviator who eventually ended up switching the cockpit to a desk for space policy, I was afraid that this area might be a little bit more theoretically, but I can only reiterate and reassure to say quite the opposite. It's more actionable and it's more realistic on a daily basis than you can imagine. In the next 85 minutes, under the guidance of 3 experts, we are going to leave this room, we are going to space and come back, and I think not even Elon Musk is able to offer that service to us today. So we are going to have 3 presentations, about 15 to 20 minutes each, to give us enough room to maneuver afterwards for an intensive Q&A session. And I really would like to ask you to prepare all your questions to use the time afterwards and challenge all 3 experts at the end of the breakout session. I'm handing over to the speakers and ask each of you, Seth, Giulia, and Laeticia, to also briefly introduce yourself and to take us into space. Seth, you have the floor.
Thank you. All right, good afternoon. This is an exciting topic, and I fully recognize that this is a cyber conference. Forgive my excitement a little bit. I have worked as a space lawyer for the last several years for the United States Air Force and some of its joint commands. As such, I hope you'll also forgive my disclaimer here. These are my opinions and the opinions of my co-author, Dan Osborne, who's with us today, not necessarily those of the Department of Defense, United States Air Force, United States Space Force, or any of the other organizations within the DoD. That said, multi-domain operations is a real current construct and a real way that we need to be thinking of things. General Nakasoni's remarks this morning were very on point when he was describing different operations and how important and integral cyber is in not just modern conflict, but the continuum of conflict like he talked about. Space, likewise, overlaps with cyber in so many aspects. We don't control satellites. We don't conduct satellite activities without having cyber activities as well, along with all the propulsion and the astrophysics and all the orbital mechanics that go with satellite maneuvers and things like that. So what I want to talk about, kind of with that framework, I'm going to talk about a couple of provisions of the Outer Space Treaty that we found really interesting and have a bridge to some of the construct and the legal construct of cyber, bridging a lot of the regulatory framework into space as well. The 2 provisions are the Article 6 and Article 7 in the Outer Space Treaty. Article 6 talks about responsibility. Article 7 talks about liability. I'll give kind of a quick recap a little nuance with the responsibility provision, and then I want to give some examples as to how cyber intervening acts affect both the responsibility and liability provisions. Now, I should caveat, as we talk about responsibility and liability provisions, I'm talking about the Outer Space Treaty, which also includes a reference to incorporation of international law, including the UN Charter, in activities in space. I'm not talking about use of force and armed attack, but Laeticia is in a few moments. And we're happy to answer questions about use of force and armed attack. But for the sake of this argument and this conversation about responsibility and liability, I'll focus on mostly areas outside of conflict. Responsibility has two aspects to it. First, states have a responsibility to govern, to legislate, conduct some kind of regulatory framework for its outer space activities. And the word in the treaty is national activities in outer space. And if you look up or Google a definition for it, it's hard to find. Of course, it's not written in the treaty. Just like many other treaty provisions, we look to things like the Vienna Convention on the Law of Treaties to try and determine what ambiguous terms are, which means look for other treaties, look to state practice, and as we look to other treaties and state practice, we see, and even statements by other organizations, including the UN, we see that national activities in outer space consist of things like that are fairly obvious, right? So launches. States are going to regulatory launches into outer space, and I think that makes sense. Satellite maneuvers, another one that makes sense. We also found the UN in particular, and a whole myriad of spacefaring states have regulated satellite communications and remote sensing. All four of these, we can safely say, are national activities in outer space. There are probably some others, and there's an interesting conversation to be had, maybe on the break or maybe during our Q&A about commercialization of space and what national activities look like with the commercialization of space. But this construct is a little unique to space, where we have states that have a treaty-bound responsibility to govern certain activities. And so that's what responsibility is. One of our arguments in this is that just the same way that space activities are governed, there are cyber responsibilities that do those four things that should also be regulated, and states should regulate those things. Launches are a little bit tricky, right? You can't. At least right now, we haven't seen any launches purely done by hacking into a system. But remote sensing, satellite communications, satellite maneuvers can theoretically be done by cyber means, by an intervening actor. All of those things, if they are required to be regulated outside of cyber means and without an intervening actor, then they should be regulated as well without that. The second point I want to make with responsibility is there's a financial aspect to this, and we haven't seen this playing out with states yet, but we have seen a lot of academic discussions about, hey, there are instances when this liability provision doesn't apply, but responsibility can. For example, if a state launches a satellite, they are the liable satellite under the liability convention and the liability provision that we'll talk about a little more deeper in a sec. However, if that country sells that satellite to a second country, the second country is now the responsible country. They are responsible under the terms of this treaty. Which means if it crashes into another satellite, it can then be held liable. It's the responsible state that's held liable. Now, shifting a little bit and incorporating the liability provision of the treaty also binds the launching state to be liable for for any damage. Now, I won't get too deep. This isn't a full liability conversation. It's a little bit. On orbit is fault liability under the treaty. So think kind of negligence in some of your common law states and how that might work. And then terrestrial damage is absolute liability. We've never really seen this play out. We've seen it invoked a couple of times, just loosely, but not in a way that fully triggered the enforcement mechanisms and convened the boards that oversee this stuff. Now, some of you are probably thinking, this is all well and good. Or maybe some of you are thinking, this is way deeper into law than I expected, and I should have gone to another room. But where does cyber come in? Well, here it is. So you've got the same scenario, right? So you've got state A that launches a satellite. They are the liable satellite, or the liable country, under the liability provisions, okay? State A then sells it to state B. We'll call it the buying state. B is in Bravo, the buying state, right? So state B now owns this satellite. They didn't have to launch it. It's on orbit already. They can do whatever they would like with it under the provisions of their government regulations, which includes, maybe taking pictures of the Earth, maybe satellite communications, whatever that satellite is set up to do and their country allows for them to do. And then we've got a cyber actor. And yes, we'll call it country C is a cyber actor. So country C intervenes and they crash this satellite into a different satellite. Now, somebody might be thinking, if only there was a slide that depicted all of this stuff. My friends, I'm here to help you. Okay, country A is the launching state again. Country B is the buying state. They purchased the satellite. It's already on orbit. Country C conducts this classy cyber maneuver, intervening act. And this intervening act can be a maneuver. We'll consider it a maneuver in this instance. And then it crashes into D, causing debris. Crashes into, I should say, on orbit, a satellite owned by country D. Okay, so causing debris. In normal terms, we would consider this liability. Without the cyber actor, we would say country A is liable. And that's a little bit of a liability loophole, right? Country A now has nothing to do with the satellite, but they are liable and can recoup damages from country B or through other diplomatic channels. That said, country B is now the responsible actor. So they have the responsibility, including the financial responsibility that we discussed, but it's fault liability on orbit. So what can they do? They can claim that we have this intervening act. No attribution needed. They just need to determine that it's an intervening act, and then they are not at fault, or at least maybe partly at fault. So if we think of comparative negligence, in some common law states have this aspect of maybe you're only liable up to a certain extent, and maybe another country is liable up to a greater extent. That other country may need to be identified if they're going to recoup damages from that other country, but as far as B is concerned, B only needs to identify that there was a cyber actor to deflect some of the liability that falls under the responsibility provisions. So where does that leave us? Well, that leaves us with a couple of takeaways given the responsibility and liability provisions. First, it leaves us with we need to account for the cyber intervening acts that can affect liability or can affect responsibility. Because we should say, too, if this crash happens terrestrial on Earth, then attribution matters, because then it's absolute liability, not fault liability. And so they're going to have to deflect, in order to deflect liability, that they have to be able to attribute to another state. That gets a little tricky, right? And so attribution becomes a real limitation. Another limitation is that we haven't seen states practice like this. We have seen states use diplomatic means to determine how much they owe each other. And that's the same in space and with other contexts. So several years ago, there was Russia and Canada had a dispute where Canada had a Russian space object that impacted the Canadian territory. And without going too much into the details, the dispute was essentially settled before they can invoke all of the liability provisions of the Liability Convention. That left them settling it diplomatically. Other situations where there's been damage on orbit, settled diplomatically or ignored. So that leaves us with, again, looking at state practice. States have chosen to settle these things diplomatically. This gives us a construct to settle it diplomatically, and I would assert that we should be conscious of how cyber affects both of these provisions and invoke these provisions, and not be afraid to say, hey, this has never been done like this before, but diplomatic means have been used before, and this is a diplomatic way to do this. The second takeaway that I'll leave you with, and we'll sum up here at the end, is that under the responsibility provision, states must have regulations to govern cyber acts. And I'll give another example. And I'll use the US as an example. So if there's an individual in the US that is affecting a satellite, right? So if we go back to the cyber means, the cyber activity that's affecting satellite B, and this cyber activity is originating in the US, this cyber activity is a national activity in outer space. It has not been applied that way, at least certainly in the 1960s, when the Soviet Union and the US and other spacefaring nations were trying to come up with the Outer Space Treaty. They weren't considering ones and zeros in the same way that we consider ones and zeros, and they certainly weren't considering certain methods and satellite communications and remote sensing and all of these things that can be conducted through cyber means, and certainly not through an intervening cyber actor or a hacker. But if that individual can hack into a satellite and conduct a cyber activity that either moves the satellite or conducts one of those activities, it is a national activity in outer space and should be governed by the Outer Space Treaty. The Outer Space Treaty, at least, says that the states should have a regulatory framework for it, just as it has regulatory framework for other means. So again, two takeaways. One is that we need to consider cyber as an intervening actor. And two, states need to govern that. And with that, I'll hand it over to Giulia to discuss our next section. Thanks.
Thank you.
Yeah, thanks.
Okay. Good morning to everyone, and thank you for the invitation. I was asked actually to discuss the possible implications for NATO in the recognition of outer space as an operational domain, which is a very hard work. And of course, I will focus only on some of the implications, plus, together with all the implications, what could be the element of further complexity determined by reversible operations. And here I focus on the concept of reversible operations rather than cyber itself, because space infrastructures can actually be target for a big spectrum of operations that just go to temporarily incapacitate the target, not limited to cyber operations against space infrastructure. NATO was not new to the space domain, of course. The alliance recognized already space as a global common in 2011, and then in 2009 and 2016. But it was only in 2018 that its member states began to consider really space as both an enabler for its military operations with the Brussels summit, but also recognized that action was needed, and at least to define some objectives when approaching space with the now unclassified NATO space policy, adopted in 2019. In contrast to some member states of the alliance that expressly qualified outer space as a warfighting domain, the alliance preferred it to qualify it as an operational domain. And this actually can have some implication on its role as an integrator and coordinator among member states to approach to reversible operation. Right now, the member states of the alliance and the alliance itself are facing a new set of threats. In fact, compared to the beginning of the space age, we had a shift from irreversible ASAT, kinetic ASAT, which were really meant to destroy the target and which now are mainly perceived, despite the fact that they were conducted recently by Russia, India, and so on, they are mainly conceived as projection of power, but rather most of the spacefaring countries are now reverting to operations also for a neoliberalist approach, because basically it's acknowledged right now that if I go to destroy the target, this will produce debris. And so we can say that now there is a new neoliberalist approach that really perceives counter space only in terms of incapacitation rather than destruction of the target. This brings us then to two considerations where NATO could actually have a significant role. The first one is that we should start to align to some of the technical doctrine, and this position has not been yet exported, for instance, in the space law discussion, that some space infrastructure should be perceived as critical space infrastructure. We have to do this step not only because space infrastructures are not self-sustaining infrastructures and are deeply cyber-dependent, among others, but also because they don't experience medium thresholds. When I go to incapacitate, even temporarily, and even if it's reversible, the space asset, then its consequences on the related infrastructures, both in space and on the ground, can still be irreversible. The role of NATO, and this is recognized in the space policy, could be to coordinate the process in the identification and then designation of critical infrastructures, which right now is only a national approach. In its space policy, the alliance recognized that NATO should develop a common understanding of concepts. NATO will consider ways to improve space resilience alliance-wide, including through sharing of best practices, and guidelines will need to be developed on how to secure and ensure NATO's access to space data, products, services, and capabilities. So from the document, it is very clear that NATO depends on its member states' space-based assets, but also that NATO can have a role in the designation of these infrastructures. And this is my first takeaway. The second take, and if you want, then I can explain which means it could be used within the NATO framework. The second takeaway then relates to the how. Because when we say that critical space infrastructures must be protected, then we have to be able to assess the type of threats that the different objects will face. And there is where, again, the alliance took already quite a strong stance, setting among its objectives space domain awareness. Space domain awareness is a very specific concept that goes beyond what was initially its precursor, which was a space situational awareness, mainly related to a benign environment. And it goes a layer further because it really, through a set of other skills and other information related also to intelligence gathering and so on, go to establish the intention behind the behavior and the space or the threat in the space environment. But SDA, therefore, is strictly linked to the ability and to the readiness of the alliance forces to react to space threats. But it has also a very technical component, which is, in the end, SSA. SSA right now, it's not implemented uniformly at the international level, and there isn't any obligation that impose under even space law that impose to states to share SSA information. And this is quite a huge gap. In fact, in the Outer Space Treaty, we have, of course, we can leverage a very weak obligation on Article 1 and on Article 9. Article 1 as it relates to the freedom and then of exploration and use of outer space, and then it connects to the information mechanism through Article 9. But we can also leverage some duty to share information on Article 10 and 11, which really provides us with the means to share this information. But then when we go to operationalize these concepts and apply them concretely, the vagueness of the treaty becomes a problem. The treaty refers to clauses such as to the greatest extent feasible and practical, so it doesn't give any hint on when this should happen, or as soon as practical. So if we then transfer this issue within NATO, it becomes even more complicated because, first of all, states can only decide whether they want or not to share SSA data. So space domain awareness, which really is based on SSA, can be severely jeopardized and could only become a political objective rather than a concrete one. And the other issue is that right now there is, as I was mentioned before, SSA is approached from a domestic or regional level. Domestic level means that even the biggest states that own and right now have SSA sharing programs, such as the US, can still decide, and they decided to impose some limitations, of course, in the distribution of data, or then in the transfer of such data to third party. This even with states that are already gathered into regional frameworks. This happens, for instance, with the EU. The EU shares SSA data with the US and vice versa, but then when we go to see how this is done through a net of bilateral agreements, with a lot, of course, of then limitation on the transfer of third parties, even within the same union. And the other issue then relates to the integration of different sources of SSA data. If, as we are experiencing, and it's expected with the new space advent, we will integrate more and more commercial products into SSA services and practices, this, in the end, will affect also the NATO security. Why? Because there's not a standardization process yet. We don't have international standards agreed there. And so it's very difficult even to ensure, for instance, that there is a cybersecurity by design that is shared by all the partners. So this could be one of the first critical issue with space domain awareness. The second issue is that, of course, NATO doesn't own capabilities, but as mentioned before, rely on the services of its member states and allies, and this happens through memorandum of understanding. And there the problem could, in the end, be that it will not have a say on any of the practices that will be established within NATO. The other issue is that if NATO wants to perform SDA, this means that there must be a center that provides such data. And right now, of course, NATO lacks of any 24/7 operational cells that monitor and then share this information. But here is also where there is a possibility for NATO to have a role in SDA. Rather than pursue SDA as an operational objective, this should really be perceived as a political objective, meaning that NATO can be a coordinator, it can foster joint states coalition, as it happened, for instance, with IRS, to promote and to agree on common practices. NATO can also foster interoperability, because one of the other biggest issues of SSA is the interoperability among the different systems. And here NATO, which has already experience in interoperability issues both in the sea awareness domain and in the air awareness domain, it can certainly intervene. And then we go at the form. How can NATO do that? My argument is that we shouldn't go with standards, any type of standards, and especially in space, because if we look at just the standardization process in space missions and space program, standardization takes really a lot of years even to happen and for standards to be developed. So it's not dynamic and it can't respond fastly to changing reversible threats. What it's at least in the first phase could be advisable is through the Center of Excellence, and now to the now the Space Center and then the Center of Excellence, could be to push and coordinate states in adopting best practices for the moment and in sharing best practices. This will be, of course, favored by the fact that, of course, it's a secure environment where to share such information, which is not the case, for instance, at the EU level. At the EU level now, the EU is facing a huge problem of trust building and agree on standards in terms of interoperability, because member states are are reluctant at least to share some intelligence practices and some information at the EU level. But this is a problem that NATO doesn't have, and here is also where NATO has an opportunity actually to intervene, and for the NATO space policy and then doctrine to intervene. Thank you.
Thank you. Afterwards we all switch.
Thank you very much. Thank you very much for the organization, Anne, and the COE. Thank you, Patrick, for inviting me to speak at this panel discussion. And before I start, I must say that I'm speaking in my personal capacity. All the views expressed are my own. They may be yours at some point, but I hope that this is clear, that I don't represent any organization or institution whatsoever. So at the multilateral level, in other words, at the United Nations level, discussions on the prevention of an arms race in outer space, they started in the 70s, at the end of the 70s. And the states decided that it would be interesting to add an agenda item at the Conference on Disarmament on PAROS, preventing an arms race in outer space. Since then, states worked on different aspects of this very point, because the main treaty addressing these questions of space security was the Outer Space Treaty of 1967. And as Seth rightly said, they didn't consider 1 and 0s the same way that we are doing it today. They just considered the prohibition of weapons of mass destruction and nuclear weapons, or they just consider the use of the orbit for peaceful purposes. This is still, in 2022, this notion of peaceful purposes to be interpreted. So for the past 55 years, the only political and legal safeguards of outer space has been this provision, Article 4 of the Outer Space Treaty, and otherwise, and it worked somehow, diplomacy and all the discussions that are being held at the Conference on Disarmament in Geneva, and some discussions also in Vienna at the Committee on the Peaceful Uses of Outer Space. So now I will state the obvious. The number of cyber activities is growing. The degree of reliance of military forces, but also of governmental capacities, and the number of important economical actors on space systems is growing as well. And the embodiment of the cyberspace in space assets, whether they are in outer space or underground, must be addressed at the United Nations level and also at bilateral level between states. So, what does exist at the international level to offer a legal protection to space operators? Earlier today, Joanna Weaver already addressed that international law applies to the cyberspace. There are discussions about the application of international humanitarian law. This is also discussions that are occurring at the UN level. Article 3 of the Outer Space Treaty says that international law applies to outer space, including the Charter of the United Nations. I will come back to this a bit later. At the moment, especially between the 9th and the 13th of May, so a few weeks ago, there were some discussions in Geneva at the Conference on Disarmament in the framework of an open-ended working group on the applicability of international humanitarian law on space activities. And this is a very interesting perspective because different states have obviously different views. So, I ask the question again, what does exist at the international level to offer a legal protection to space operators, whether they are military or industrial or governmental? Not so much. The Liability Convention may be mentioned. It was brilliantly said by my colleague. It applies to the damage. It applies to launching states. There are some mechanisms that can be put in place. My colleague also mentioned the possibility to have some mechanisms, maybe not standards, maybe other mechanisms, but this is a discussion that must be held between the different actors. And my part will be on international law, what exists at the moment. So the rules relating to the use of force as provided by the Charter of the United Nations could be of value when assessing threats emerging against space activities. We are talking here about a general prohibition of the use of force or threats of use of force. So the question is, what qualifies as use of force? So I'm asking the question now so you don't ask it to me because, it's not up to me to have an answer, but I can try to put together a spectrum of criteria that can be used if states decide to go out from the gray zone. So can a cyber activity causing harmful consequences, physical consequences, be considered as use of force? And when does it amount to an armed attack? I will be very cautious also not to mention cyber attack. I will talk about cyber activities because it's the same. We lawyers, we like to define, we like to be sure that we are in this little square of definition. I don't have a definition for you about what constitutes a cyber attack. So here I will focus on what could be the threshold triggering the qualification of use of force. And it's an important discussion to have because cyber activities, they are not new anymore. They are very much a part of our world, both on the ground and in outer space. And this is why these decisions must be taken by the different governments when they agree on how to react. Because when you qualify use of force, you also qualify what could elicit a response and eventually a countermeasure. And I invite you to have a look and to read the last publication of Michael Schmidt on the different replies to a cyber attack. It's very interesting, and I will be very happy to discuss some of the points with you. And I'm sure I've seen him somewhere that he will be very happy to discuss. I was distracted. Yes, that he will be very happy to discuss it as well. So, when trying to adapt international legal instruments Policymakers are perplexed by technological innovation, but it cannot be the case anymore. And this is one of my points. So what criteria should we consider? In international law, the International Court of Justice decided that to classify an operation as armed attack, lawmakers must take into account its scales and effects. The standard of evaluation could be any use of force that injures or kills persons or damage or destroy property. So maybe you have at the top of your head some cyber activities that occurred in the past. I can cite, I don't know, against space systems, the Viasat issue that occurred on the 24th of February. I can mention the most recent Starlink breach that occurred, but that was quiet, not easily, but at least quickly addressed, I will say. So for some experts, you know, the standard of evaluation could be any use of force that injures or kills persons or damage or destroy property. And this is important for me to repeat this, because what about cyber theft? What about operation of intelligence gathering or temporary interrupting non-essential cyber services? Can it trigger the qualification of use of force? Question mark. This is also up to states to decide, but for instance, a few years ago, the Ministry of the Armies of France publicly stated that there was an issue with one of the satellites, a Thales satellite, Athena Fidus, and a very close approach. No damage, no issue. Or intelligence gathering, big issue. This is exactly the type of consideration we must take into consideration when qualifying. And for some experts, if they target states' critical infrastructure, the threshold is reached as well. And my colleague mentioned the issue with critical infrastructure. This is a individual state's decision. This is also something that could be triggering, and this is something that must be decided. So now, with regards to cyber activities related to space assets, states are very much aware of what their critical infrastructure are. Of course, there must be a list somewhere of the different critical infrastructure placed in outer space or on the, different ground systems, and what could be protected by all means. But we must take into consideration commercial actors as well. I will come back to this a bit later, but what a critical infrastructure is very important, because this is how we measure easily the gravity of the effect. In other terms, the consequences of cyber activities, even though they are less apparent or visible than those resulting from kinetic attacks. I mentioned the open-ended working group that took place in May. So there were different approaches that were taken by states. Of course, there is the approach by NATO that is quite criticized because there is no definition of what a weapon is. There is no way to verify exactly right now what is happening in outer space. There is an approach based on the behavior, but this is also tricky because it's very easy to, draw a red line on what had been perceived as a problematic behavior. And then it creates a miscalculation, so another activity, and an escalation. And this is grossly said, but the behavior and just focusing every single decision on how a state behaves is quite dangerous because it can create misperception, and we don't want this. Now, another approach that was proposed by France was to study the effect of an attack. And it's detailed in the paper that was submitted on the website of the Office on Disarmament Affairs. This is a public paper. You can access it if you type OEWG space ODA, and you can have a look at this approach by effect. It means that the consequences of a harmful operation or harmful activities, it's what should be taken into consideration. So this is about quantifying and identifying the set of consequences. This is what matters. Whether they target a system that is commercial or a military one, we can also see that in cyberspace, an activity can spread, a code can spread through the different infrastructure. It happened in the past, it's happening right now, and it will happen in the future. And in outer space, there is no segregated zone where, like there are military activities from a side and commercial activities from another side. Every single individual action has collective consequences. For instance, because of the creation of debris, or because of you have like an object that stays in orbit, or something like this. This is something that must be considered. So I will put aside for now the issue of attribution, and this is why I only focused on the effects, because attribution is a full question, and I don't have time for this if we want to take some of your questions. So as I said, the cyber domain is incorporated into military operations. There is a long-standing and increasing reliance on digital technologies, systems, and equipment. Any disruption in cyberspace is an underlying source of tensions. And with space systems, all reparation or maintenance operation can only be done remotely. With a satellite connecting tons of thousands of terminals for civilian uses, but that also includes the management of significant sources of energy. We've seen it with Viasat. A cyber activity that could disrupt this type of system has very harmful consequences. Tens of thousands of terminals out. And it creates also bad possibility, it creates a lack of possibility to manage remotely, for instance, the wind system, that provides energy. And this was this type of consequences that we want to address. So if we think about the Starlink constellation as well, I mentioned it a bit earlier, it's a large constellation of satellites populating low orbit and providing capacities to all types of actors. And therefore, this has the potential to be extremely complicated in terms of consequence. So, for instance, we talk about populating the low orbit. It can prevent, if one of the system or the full constellation is down, it can prevent or make more difficult the access to space. And all of the access to TTNC, so telemetry and control, through the servers, the propulsion, the capacity to avoid collisions, if they are down, you have thousands of objects in orbit that cannot be controlled remotely anymore. Any cyber activities must be carefully envisaged because of the magnitude, the importance a damage can have. So now another question I will ask is, do we have time for diplomacy to happen? I mentioned the open-ended working group and the work that the different states are providing. It takes time. It was only 5 days in May. It will be 5 days in September. And states are, putting together, working a lot on how to qualify a threat, how to find the best legal instrument. And this type of dialogue takes time. But the issue is that the cyber activity in outer space, it's happening now. It's very much a current issue. And we've been discussing since 1981 about the prevention of an arms race in outer space without real concrete outcome so far. And that's something that could be a bit concerning. And this is why it's something that must be a political will for states, for intergovernmental organizations also, to just bridge the discussion and to push it forward. And we must continue these discussions considering all the stakeholders, civilians, governmentals, military, and we we must bridge the discussions. And I think this is a very important point, because outer space is a shared domain where individual actions, as I said, have very collective consequences. And with the emergence of new space actors, both states, new states that are new space players, and the industry players, we must bridge the discussions at the Conference of Disarmament in Geneva, but also at the Committee on the Peaceful Uses of Outer Space in Vienna. It's not a possibility now to work in silos with military from a side and commercial actors from another side. This is just bridging discussions, not taking decisions the one for the other. And this could be very interesting for the future of space activities, because we can benefit from lessons learned, we can benefit from best practices, especially in the cyber world. And there are technologies that are available, for specific companies. It takes some time to be shared a bit more broadly. And this is how we can build for the future legal instruments that will be efficient, not necessarily binding, but efficient. And what happened with Viasat, what happened with the Starlink constellation, these are good examples on why we have to have this dialogue involving all the actors. This will help states analyze together to face misperception issues that could lead to misunderstanding and miscalculation, and eventually it will bring more clarity on what could elicit a response. One's behavior, can be triggering a reaction that can have very harmful consequences. And if you decide to reply or to, counter a current armed attack or a current use of force because you decided as a state to qualify it as use of force and to use a countermeasure, you cause debris, you cause damage, it has also, there is a domino effect of consequences. And all of these discussions involving all the stakeholders, they will help states to prevent an escalation and perhaps offer a better protection overall to all space operators working on both the civilian and military side, because neither in cyberspace nor in outer space we can deny an interconnection between all the stakeholders. Thank you very much.
Do you want to sit over here?
Thank you very much. So if you are overwhelmed by now, then you're right, that this is a legal session. Thank you very much for the introduction and also bringing light into this very complex environment. After each presentation, you might get the impression that cybersecurity in outer space is not only doubling the complexity, it's more than that. And you're not wrong in that conclusion. Even creating a proper situational awareness, counting ships coming from the Navy, counting airplanes, seeing what they are, flying planes and so on. This is not that easy in space. And we are still at the beginning of trying to establish a system within the alliance about this. And actually, everything you just heard is not something, as I said at the beginning, theoretically. It's happening every day. At the desk office for space policy in the German Ministry of Defense, we are having these discussions every day in our email boxes, on the phone with our colleagues of the Ministry for Foreign Affairs, Ministry of Transportation, just national. We are also having daily calls with the European Union representatives, also with our NATO colleagues and so on, to really tap into this environment. And I also would like to mention at this point, before we go to the Q&A, that this is the chance of the upcoming Space Command under the NATO umbrella to really go and tap into this environment as well, especially the space COE. This is where I see the lessons learned also from the Center of Excellence, what we are doing here when it comes to cybersecurity. This is the vision that the space COE in France should have also to support the NATO and the alliance and partners to also bring light into these topics. But let us go to the next slide, because we prepared a summary for you. So you can take the pictures during the Q&A, and I already saw someone raising their hand, so the floor is open. Go ahead. We need some mics. Thank you. Good idea. That's you.
Thank you. My name is Kuba Mačák. I work at the International Committee of the Red Cross as a legal advisor. And so I I'm going to shoot the question without having read the summary. So hopefully it's not answered on the slide and I'm going to embarrass myself here. So first of all, congratulations to all three speakers. I found all of the presentations really illuminating, in depth, and I think what is really important is highlighting all the threats, right, and the potential human cost that the uses of space assets and also this interconnection between cyberspace and outer space may have. My question is for Laeticia, for the last speech that we have heard, and I wanted to unpick one of the assumptions that you have made, if I understood you correctly. Towards the beginning of your presentation, you said that what protections are there for space operators and for others, both civilian and on the military side. And I think the quote was not so much. There is not so much, right? And you referred to the open-ended working group discussions that were going on in Geneva earlier this month. And I think it's fair to say, as you did, that there was some discussion about the applicability of IHL. And of course, those of us who were here earlier today, we heard Joanna Weaver talk about how the same kind of arguments were raised in the GG and OEWG for cyber. But I would push a little bit back on that. When we say that there are no binding rules or we need to think about new binding rules, IHL are those binding rules that we have and that protect the various categories of people and also of objects in time of an armed conflict. And so to the extent that there are some arguments that maybe it's premature, maybe it's politically problematic to talk about applicability, we should view them in the context of where these arguments are made in these diplomatic negotiations. And we can also bear in mind what happened in other processes that we have heard about, that in the end, a consensus can be reached on these things. But that's maybe, you could say, a very soft political point. But let's look at the hard law. So we have Article 3, that refers to all international law, as you have said. It incorporates all international law. So I don't think it's much of a stretch to say that IHL is a part of international law. So it's already being incorporated, through this way. Then in IHL, we have Article 36, which tells us that IHL, Article 36 of the first additional protocol, which tells us that IHL is a technology-neutral body of law. Whenever there is a new technology being developed, it's subject to legal reviews, an obligation of legal reviews, whether it complies with IHL. And so that would probably also apply to space applications. We have the logic of the nuclear weapons advisory opinion, which says that IHL applies to all kinds of weapons, those of the past, those of the present, those of the future. So hopefully, again, we can extend this to the space environment. So I think there are very strong arguments. And on top of everything, when we talk about these double complexities between cyber and space, we also have the acknowledgement in the cyber context, in the GG, that IHL applies. So I wonder, if we're not doing ourselves a disservice by reopening this can of worms that has been closed, at least in some ways. And I would be curious to hear the views of the panelists on that. Thank you.
Yeah, thank you very much. Let's go the order backwards, like first Laeticia, then Giulia, and then Seth. And of course, backed up by logistical support by Mike Schmidt.
Thank you very much for your question, and I'm very happy to see that there is a representative from the ICRC attending to this panel. Indeed, it's a topic that, according to some states, should be, like a self-applying topic. So it should be obvious that IHL applies to this type of activities that are being carried out in outer space. It's not so obvious, and we have to open the discussion. Your colleague Wenzu from Geneva, she took part in the discussion last month, and she made a brilliant presentation of the applicability of international humanitarian law. And a lot of states just agreed with the applicability of international humanitarian law. But some states that may be considered as important players decided that it will not apply for some reason. One of them would be don't feel free to have a look at the documents I mentioned on the OEWG, but that considering that IHL applies would be considering that outer space is open for conflict, grossly said. And this is something that really triggered some reactions. And this is something that we must vote, we as states, we must vote and put on the paper and be sure about. And yes, we have to open the discussion, we have to write it down, we have to have the signature at the bottom of the page, and then it will be obvious.
Giulia, do we have comments?
Yes, I don't have much to add actually, and I totally agree actually that we should now acknowledge that it's just applicable, of course, to the space context, and it's actually quite surprising that the same states that then object to the applicability of IHL then develop, for instance, counter-space capabilities as part of their defense policies, even without recognizing space explicitly as a war-fighting domain. So actually there's a bit of a dichotomy in that regard. So I agree on that. And then I think that the necessary step is really to jump immediately in what could be the consequences of the counter-space conducted within armed conflict, because then there is the real meat of the real substance of the discussion. I think it's pretentious right now, and it's a political, probably also position to continue to contrast this approach to the application of IHL, and it reflects, in fact, as Laeticia was mentioning, years actually of documents proposed within the CD that just stalled the discussion, in fact. And so that's my comment.
Thank you. Seth?
Yeah, I think the conversation around your question really depends on what protections we're talking about. So if we're talking about protections in armed conflict, then yeah, I think this is a great conversation to have. Certainly, we've got the Article 3 reference to international law that's been discussed. One of my go-to quotes from one of our DoD senior leaders is, "There's no such thing as war in space," or "There's no such thing as cyber war. It's just war." Right? So whether it extends to whatever domain, the maritime, land, air domain, it's going to be the same. It's just war, and so it's just conflict. But if we're talking about instead of those kind of protections, and instead talking about protections for harmful interference, for example, well, that's a little more complex of a protection based on language in the Outer Space Treaty that's undefined. That language, at least in Article 9, and I won't get too geeky and presume that everybody has memorized the Outer Space Treaty. I know there are only a few of us that level of nerdiness, I guess. But if Article 9 says that you can't harmfully interfere with another nation's freedom of exploration of outer space without first consulting. It doesn't mean you can't do it. It's not a prohibition. It says you can't consult. And of course, we've seen states do that. But that's an example of a protection that at least in state practice, hasn't been as solidified. So I love the question. I think it depends on the, I'll give a good lawyer answer. It depends. It depends on the kind of protections that we're talking about. And certainly it's worth exploring and fodder for all sorts of academic articles for someone to write. Thanks.
Thank you. Some additional comments? Sir, if you might. Are you?
Hi, I'm Mike Schmidt, one you were looking for earlier. Let me add to what Kubo said. Kubo went to Oxford, so he gave you a very detailed scholarly view. I went to the University of Texas, so let me tell you what I told the Chinese ambassador on the issue of the applicability. Mr. Ambassador, that's absolute nonsense. And the same is true with regard to space. Anyone who suggests that IHL does not apply in space is a lousy lawyer, because it is crystal clear. I'm 112% certain that IHL applies in space. So I don't feel strongly about this, but there's my view. But that's not my question. My question is for the Colonel. I think there's an interesting situation going on with Starlink providing information that's valuable to the Ukrainians to conduct hostilities. If under, and you probably anticipated this question, I'm sure you've talked about it at the office, if a state is responsible for its national activities, then I assume the United States is responsible for the activities of Starlink. So how does that tie into neutrality? if Starlink is giving militarily useful information to the Ukrainians, a belligerent party to an armed conflict, would that mean that the United States would be in breach of any neutrality obligation? Now, it isn't, I'm not trying to do a stump the dummy question. My view is no, because I'm an advocate, along with Wolf von Heinig and a few others, of the doctrine called qualified neutrality. But I haven't heard the United States speak to this issue. So I'm wondering if you could give me a sense of what the Americans are talking about.
Yeah, thanks. So the Starlink situation is fascinating already, right? So we've got a private actor in a world that we really haven't seen something like this before. A private actor supplying, one of the states with a useful tool, and what has been proven to be a useful tool, at least what we've seen over the last few months. But the state itself is trying to stay neutral, or at least presumably so. Responsibility, I wouldn't. So I take an expansive view of responsibility, right? I have colleagues who wouldn't say that it expands as much as I've asserted here today in financial obligations. That said, I think the responsibility provision would expand to something like Starlink in a financial perspective. Well, because
Responsible period. And then it
well,
into financial responsibility, but put that aside. Why are they not responsible for Starlink's actions? And which means that they're U.S. actions, which means that's a breach of classic neutrality. Not
Sure. Definitely could be. I mean, so I'll speak from my own perspective again, right? Because I don't know what the U.S. stance is or what it's going to be over the next few months. I think of responsibility as, like I said, financial and regulatory framework. Starlink has to operate under the regulatory framework of the United States. And they will have to do so because that's where they're licensed to operate, and that's largely where they've launched from. I may be wrong on some of the details as far as where they've launched from. Regardless, they needed US licenses to operate all of these satellites in lower Earth orbit. That might be tested a little bit more, right? I mean, the US wants to support the Ukraine and support this company that's helping Ukraine. And so if they're going to be in violation of a regulation, would we expect this company to be the company to do that? Yeah, maybe. And that may test the regulatory framework of the US. As far as it hits the neutrality issue, then yeah, the United States is responsible for their actions insofar that the United States can control this company, right? So maybe in other states, they may be able to control a private actor a little bit more or a little bit less, but they certainly have some responsibility to control this actor. To what extent is to be determined. So I'll take the side of view of qualified neutrality, because I think that's an important aspect of it where some people haven't gone that far. Thanks for the question.
Yeah, fantastic discussion. Thank you. Row number 3, please. Thank you.
Hi, thank you so much for the discussion. My name is Seth. I'm an associate professor of law at Indiana University. My question is also for Colonel Dilworth, and it directly ties to the summary you provided on the screen of what was a great presentation. When I don't teach international law and cybersecurity law, I teach tort law, and so I'm really curious about the way you've taken your analysis, and I have 2 questions in that regard. One is the use of intervening action phraseology from what is predominantly common law doctrines. I'd be curious your understanding of how you conceptualize them as intervening and or superseding causes, particularly as it relates to how commonplace cyber attacks have become and cyber intrusions have become, and therefore whether they are foreseeable or not foreseeable anymore, justifying or not justifying relieving of liability, state B, using your example, and whether we should hold state B liable if it failed to comply with basic cybersecurity measures. And I only raise this because we've seen many private entities in domestic contexts rely on intervening superseding causes in the context of vulnerability abuses that they could have stopped by saying, but China did it, so I should not be held liable. So I'd be curious to hear how you play that So that's question one. Question two is about insurance. So the more we rely on the liability convention in the cyber context, the more that I'm worried about insurers willing to insure outer space practices, which we already have witnessed a decline and concern by insurers. And now when we add cyber issues, I can only imagine they will want to pull out even more.
Yeah, man, a question from a torts professor. This is great. Yeah, so a lot of this is kind of borrowed from tort law, right? Certainly, those with common law states can relate to maybe conversations about negligence and comparative fault and things like that. All right, so I guess I would say, yeah, it really is similar. Should a state anticipate cyber actions against its satellite? I would say yes in a modern era. Now, our problem, and we had an awesome conversation last night, really geeky conversation between a bunch of space lawyers over drinks last night. But where we were talking a little bit about this conversation. Should we expect it? Well, we have modern satellites that do that. Now, our problem is we've got a whole bunch of satellites on orbit that are sometimes decades old. Do they have those patches, or do they have even the capability to have some of these vulnerabilities shored up? Well, I don't know. And that's probably a great question for some of our astro engineers who can talk about that, or maybe can't talk about it, right? So yes and no. And I think that parlays into your second question about insurance. Insurance is getting way more complex already when it comes to, we have these multi-million-dollar space robots, conducting all sorts of activities that we, as world citizens, all rely on for banking, for navigating, for trying to get to the icebreaker last night, for all sorts of stuff, and these insurers want to play a part in it, partly because there's a huge financial incentive for them to do so. But once it gets more complex, not just with the space operations, all the debris, but also with the cyber operations, I think they're going to overlay their cyber framework. This is what I would think of as an insurer if it was me. Overlay your cyber framework that you're already using on the ground for terrestrial cyber capabilities, right? That includes how much should they be protecting already and how much security should they have. Put that on top of whatever space framework that you have as well, and you're going to have to do this in degrees, because some countries have the ability to launch satellites with more cyber protections than others. Some countries have older satellites that are going to last maybe a long time and maybe not so long. And some countries just don't have that capability at all. So again, it depends, but I think we're emphasizing one of the complexities here, and a reason to have more panels like this, right? Because the crossovers, we've always had binned silos of this is cyber, this is space, this is maritime, this is air, and the crossover is just so profound right now that these conversations are fascinating. Thanks for the question.
Laeticia, Giulia, you also want to comment?
Yes, I want to add something to the insurance issue, because I think that actually that could also be managed through STM regimes. I mean, all the international community, not only the space community, we are witnessing the rise of a new concept for space traffic management and new regional approaches and framework to STM. So part of the an STM framework is also the legal component, and how actually it will be at least how the state discharge itself from the obligation to control and authorize its national activities. So if we ground insurance regimes to the mission itself and to the authorization to perform missions and so on, this will inevitably lead to an insurance mechanism that will be agreed, initially for sure at the regional level, and then once all the different systems are integrated at the more international level through practices, at least some practices agreed. So,
thank you.
Yes, I don't have a lot to add, but just it's also about risk mitigation measures, right? It's also about does the company take the choice to invest in some technologies, protective technologies, safety measures, you know, like preventing any risk of having like an internal breach. It's how does the company prove to the insurance company, for instance, that they acted as a reasonable and prudent actor. And this way, you know, we can see that they took into consideration all the different factors. And another point is, shall states, when granting the license, you know, authorizing the space activities, should include also cybersecurity by design, you mentioned
Exactly.
it.
And
It's like Giulia got it all, you know, like by design, they should have at least some protections.
But this goes again through STM regimes at the national level. So you can rise the level of protection and security that you want to ensure to the different missions, that the different mission ensures. So.
Thank you very much. If I may add as well, and also to advertise a little bit about the experience in the maritime domain. So actually the questions are quite similar. If you see a ship at sea, outdated systems, unpatched, and always connected. So kind of a similar situation. However, the United Nations International Maritime Organization is pretty strong in comparison. And there you see an entity that is strong enough to create guidelines, and they will be adopted with different companies or other organizations and kind of spread regionally. And with time, you get something at the end of the production life cycle. However, we, and in our discussions, we don't see that in a space environment yet. I mean, the existing offices, they are not strong enough in comparison. So we hope that your European Union approach or whatever could help us in this regard. Thank you. Next question, please. Fourth row, fifth row.
Hi, thanks to the panelists. Pete Cooper. One of the things that sort of strikes me is that a satellite happens to be a computer that's in orbit with fantastic connectivity. An aircraft happens to be a computer that flies with a fantastic connectivity. And we're looking at increasingly a blurred line between aviation, suborbital, and orbital. Do you see a lot of, I mean, where the domain is going for space? Did you see parallels being drawn between aviation and space and learning lessons from the aviation area and what ICAO have been doing and what different states have been doing? And you've mentioned maritime, for example. How do we project forward to make this easier for both manufacturers and operators of the assets that are going to be straddling both of these domains in the future? Because it feels weird to be splitting them.
Good question. Who wants to go first? Any ideas?
I'll go first. So we're seeing in some cases, well, I'll use the Space Force, for example. Just recently, I think within the last week, there's been some media about the new cyber framework for the Space Force, right? And I haven't seen it, but I suspect that is going to be similar to a lot of the other broad regulatory framework that is just that. It's just broad, that says we need to have redundancies, shore up known vulnerabilities, things like that, and the capability to build it up in the future. I think some of those are the lessons learned that we're getting from the maritime domain, like Patrick just talked about. But ultimately, I think that's it. I think they're going to be broad, and I think we're going to have to see because we can fix everything right now and then launch it into space 5 years from now. It won't be we're going to have more issues. So overall, to me, it sounds like the capabilities and some of the lessons learned that we've seen from the other domains are really just that, capability questions. Can we give it the capability to become more secure? I don't know if you have something else.
And if I may add a point on the, application of analogies, there is a possibility to draw some parallel between what's happening in the maritime sector, of course, the aviation sector. These are discussions that are occurring between experts and diplomats. In May, my colleagues Charles Dottler from the University of Mississippi and Almudena Azcarate-Ortega from UNIDIR, they discussed about these different analogies. And the diplomats were extremely receptive to this type of things because in the end, if we have if we are applying the best practices from a field to another, it's the best defense, and the best defense is also the best deterrence against an attack, if I may. So this is definitely something that is taken into consideration. And also, if we think about the space domain as a whole, like the ICAO has its own system, and I know that the past few years there were discussions about ICSO, so International Civil Space Organization, and it's a big question. There are discussions happening, there are debates. In the end, it's I guess states and big players that will take the final decisions, but these are current discussions. I don't have a final answer for this.
Yes, just to add, actually, yes, there are analogies that have been drawn also at the really consensus building among states and then in international negotiations, both actually with the law of the sea and the law of airspace, and always in relation to the safety of space objects. So analogies actually have been drawn for STM. With the ICAO, of course, and specifically actually with the Chicago Convention, there are a lot of provisions that in fact can be adapted or somehow tailored to address the space complexity. But also and this is more for really the part of the safety requirements and in terms of sharing of information that is very much linked actually to the law of the air. But on the other side, also with the law of the sea, it's very interesting, the analogy, because some of the main freedoms in the outer space are actually resemblant to the freedom of the high seas. So of course there is a connection within with the two domains. And there it's very interesting, for instance, to draw analogies, for instance, on the enforcement part than on any STM regime. So actually, space is already learning lessons from the other regimes by analogy.
Yeah, this is also what I would like to comment here is kind of not to see the Chicago Convention or the Law of the Sea Convention as kind of by article or provision by provision, more or less like a lessons learned, how to get so many nations on the same table to agree upon the same things. I'm still surprised that this has happened in the past. Still a wonder for me, and I seriously hope this will not happen in a way like it did in the past, that we need some accidents in space to then finally come on the same table. Maybe we can finally extract what we have learned in that processes and to do it beforehand. Next question, please. Over to you.
Okay, thanks to the panelists for wonderful presentations. My name is Jakub Harashta. I'm a law professor in the Czech Republic. And I have a question. I would like to circle back because I like silly hypotheticals. So I would like to circle back on the issue of qualified neutrality and of Starlink in the Ukraine-Russian situation. Yeah. And my question is, if US is still neutral, but Starlink is providing crucial services to Ukrainian army, what if Russian Federation decides to shut down Starlink satellites? Is it violating neutrality? Or because kind of the capability to launch satellites and provide these types of services is a bottleneck in a way. Not every state can do it. So can we outsource these sort of capabilities to ensure that the infrastructure is going to be untouchable so we wouldn't violate the neutrality of non-participating state? Or is this silly hypothetical in any way going in the right direction? I'm risking that Mike's going to berate me for not knowing this. I understand that perfectly. I'm willing to take the risk. So this is my question. Thank you. I
didn't realize we had so many professors in here. That's right. It made me a little more nervous. I want to make sure I get your hypothetical correct. So you're saying if Russia impedes Starlink's ability to provide that service to the Ukrainians, is that right? Yeah. So my mind immediately goes to, and maybe just because I think of the space law architecture first, my mind immediately goes to, and they probably have other thoughts on the neutrality of the Outer Space Treaty, right? So we've got a freedom of exploration provision that has been argued is also customary international law. Sputnik launched 10 years before the Outer Space Treaty, and the US, in response, did nothing, right? Didn't criticize the Soviet Union, but instead tried to develop other satellites to launch because we wanted the freedom of exploration as well. In fact, that was one of the main points of agreement in the Outer Space Treaty that didn't have to be left vague, and now we might consider it vague. Freedom of exploration is fairly vague or broad. But so we've got Starlink, an actor that's the United States has responsibility over, and they're conducting operations, activities in outer space, and they have a freedom to explore. And if Russia is interfering with that, then I think, of course, there's no enforcement mechanism, but I think we have at least a point of contention under the Outer Space Treaty that we can try to resolve diplomatically or some other way. I've talked enough about neutrality, so I'll let Laeticia talk about it, because I think she's got some thoughts on it as well.
Let's say that it's about protection of thought, perspective, view, and power, of course. And, I believe your question is bridged more with the question from the ICRC than with the question of Michael Schmidt, because what happened is that some states, including Russia, contest the application of some rules that other states agree on. And this is what we must consider, and this will be more a diplomatic issue than a legal issue. And this is why I don't have a strong answer, strong reply to your question.
Yes, I don't have either a precise answer, but maybe an observation, which is actually very interesting, that this could actually lead to understand and to fill of content how states should ensure the respect of their obligations under the Outer Space Treaty. Because if we link it to the responsibility and the regime of objective responsibility that is unique to the space domain, then the answer could be that the US is not performing its duty to control and supervise its nation's activities. So if we link that to that, then we can understand if the state is violating or not its neutrality. So I think actually they should be analyzed in relation to the space law regime.
Thank you, Professor Schmidt. You would like to add something? Mike in the first row, thank you.
Please,
you are looking so eager.
So listen, I think there's a lot of confusion about neutrality. Neutrality is about a state violating its legal obligation, which is why I asked the question of the colonel. I was trying to determine whether or not we could say that a Starlink operation is attributable to the state by virtue of Article 6 of the Outer Space Treaty. I'm kind of with the colonel, I'm not so sure you can say that. So let's say you cannot say it's the operation of the United States. That being the case, there's no longer a neutrality question. Why? Because the object is in the commons. If the object was in the United States, then you may have a neutrality, but I don't think there's a neutrality issue unless you want to argue that the United States is responsible for putting into the operations, the guidance, and so forth on the ground. But here's the real answer to your question. The real answer to your question is that's a military objective. Okay, that's pretty crystal clear. If that Starlink is providing information that the Ukrainians are using to conduct military operations, it's a military objective, and it happens to be sitting in the commons. That means the Russians can shoot it down. I think it's that simple.
And not only that, but we're seeing, this is a great conversation, and I know we're short on time. Cyber and space both have a lot of assets, if we call it that, or capabilities that are dual use. Dual use then becomes lawful targets. Understandably so, right? So if we're talking commercial space, and there could be conferences and papers and books on commercial space, and we're developing that. I think over the next couple of years, we're going to see more of that. But commercial space actors are cognizant of that, right? SpaceX was well aware what they were doing when they put a bunch of Starlink capabilities within the Ukraine. They know that they can become a lawful target. At the same time, and it was very public what Russia did to their own satellite in lower Earth orbit last November. So lawful targets, ripe for conversation, ripe for academic discussions over the next few years, both in cyber and in space, and I would posit both of them together as well.
And also, it's not only about like dual use. There is another distinction that is dual purpose. You know, like this dual use is more like the GNSS capabilities that are used by both type of actors. Dual purpose is, for instance, a civilian object that will be diverted to be used for destructive purpose. And this is really something that will also trigger additional questions.
So thank you very much. Unfortunately, we need to close this session. However, please give a great applause for the subject matter experts here.